I'm going to discuss how the Office of Special Counsel processes what's called a prohibited personnel practice complaint. There are 13 prohibited personnel practice complaints. These are generally prohibitions that offend the merit system. There are 2 accompanying videos that go into detail on specifically what each of these 13 prohibited personnel practice complaints comprises. So here we're going to talk about process. First, if you're not sure that what you want to file with the Office of Special Counsel falls into one of these 13 prohibitions, then you can call our 1-800 number or visit our website for more information. And as I stated, you can also view one of the 2 accompanying videos. When the Office of Special Counsel receives a prohibited personnel practice complaint, it's assigned to what's called the Complaints Examining Unit. In this particular division, an analyst is assigned to review whether the allegations raised fall into one of those 13 prohibited personnel practices. When they make that determination, there are a couple of different options. One is that there's insufficient information to show that the allegation constitutes one of those prohibitions. In those instances, an employee will receive what's called a preliminary determination letter. That letter will provide the employee an additional opportunity to respond, as well as an opportunity to provide additional information that they believe may impact their case. For those cases where a determination is made that one of the prohibited personnel practices may have been violated, the analyst in the Complaints Examining Unit will refer the file for what's called a full investigation to the Investigation and Prosecution Division. Before I talk about the process in the Investigation and Prosecution Division, I'd like to cover 2 different areas. One is the Office of Special Counsel's authority to seek what's called a stay. What is a stay? A stay is, in essence, a delay in a personnel action that's proposed to be taken or has even already occurred. For instance, you have been issued a termination from your federal employment, a proposal to terminate, or in fact, you've already been terminated from your position. When you file your complaint with the Office of Special Counsel, you may also request that the Special Counsel review your case to see if it's appropriate for a stay of the personnel action. That delay, if the Office of Special Counsel finds that there's reasonable grounds to believe that a prohibited personnel practice has occurred, they can request that the agency delay that personnel action while the Office of Special Counsel investigates. In addition, the Office of Special Counsel has the authority to file a request with the Merit Systems Protection Board, again delaying that personnel action from occurring while the case is being investigated at the Office of Special Counsel. In general, only the most egregious personnel actions are viewed for consideration for a stay. The other area I wanted to touch upon is if your case is one that has been referred for a full investigation, most cases are offered the OSC's Alternative Dispute Resolution Program. There's a separate video that covers the processes in the Alternative Dispute Resolution Program. If your case goes and is handled by the Alternative Dispute Resolution Program and it's not resolved, your case will continue along its same path and be assigned for investigation and potential prosecution with the Investigation and Prosecution Division. Well, what is the Investigation and Prosecution Division? This division is the 4 field offices that are assigned to investigate and potentially prosecute an allegation of a prohibited personnel practice. There are 4 field offices, one in Washington, D.C., one in Dallas, Texas, one in Detroit, Michigan, and one in Oakland, California. Generally, cases are assigned to the different geographic offices based on the geographic location of both the witnesses, the employee who's filed the complaint, and/or the subject officials who will be interviewed in such an investigation. Those cases are assigned to an investigator and/or an attorney for investigation and prosecution. The investigation of the case is sometimes delayed depending on a few factors. First, if the case is a priority case, it will go to the top of the list of the employee who's been assigned to the case. So that means if we're seeking that the agency delay a personnel action, those are the types of cases that would receive priority investigations. For most other cases, cases are investigated in the receipt from which they come to the office. So the older cases do get reviewed first, again, assuming that there aren't priority cases in front of those cases. Depending on the employee's docket, who's handling the case, the attorney and/or the investigator, there may be a delay in the time between the time the case is referred for a full investigation and when the active investigation in the case commences. Once a case has been investigated, what happens? Well, there's a few options. If there are reasonable grounds to believe that a prohibited personnel practice has occurred, the Office of Special Counsel generally will approach the employing agency and engage in settlement discussions to attempt to settle the underlying personnel action or personnel actions that were taken. The other option is if there was insufficient evidence to proceed, then similar to the complaints examining unit process, the investigator or attorney would send a letter and essentially a preliminary determination letter, which would provide the employee the opportunity to respond and to provide additional information before the final decision is made on whether the case should be closed or not. If the agency, in cases where corrective action is sought, if the agency declines to take corrective action, the Office of Special Counsel goes through a process by which it issues what's called a prohibited personnel practice report to the head of the involved agency. Again, another request that they take appropriate action to solve the underlying prohibition. If the agency declines to take such action, then the Office of Special Counsel has the authority to file a complaint with the Merit Systems Protection Board, which is an administrative quasi-judicial agency. Those are essentially the three options for a case. In certain cases, the Office of Special Counsel may also seek disciplinary action against an accused official, following generally those same processes I just covered. For more information on remedies and the specific prohibited personnel practices, please see the two accompanying videos.